welcome to my channel. Today we're going to be talking about maintenance. Please remember to like and subscribe to my channel. So you would approach the maintenance court for one of the following reasons, either for a new application, an arrears application, or for a variation of an existing order. For the most part of today, we're going to be dealing with a first-time application. A lot of people will find it very daunting. So the first thing you need to know is which court to appear, and that would be in the area where your child lives, because that's considered the jurisdiction. However, there was an amendment in 2015 which makes allowance for you to do an application in the area where you work. I suggest that you download a copy of the J101 and fill it in before you go to court, because then you can fill it in at your leisure. And if you're not too sure, then you can always jump onto the group, Child Maintenance Difficulties in South Africa, and ask for clarity, so that when you go to court, that at least your form is ready. And also make a copy. You need to have a copy of every single thing that you submit to court. Files go missing, so rather be safe. The documents that you are required to take to court with you would be the birth certificate, your ID, because you're the one who's making the application. You would need proof of residence, not older than 3 months. So this can be an account statement or a utility bill, which is your lights and water. You also need the details of the father or the person that you are requesting to pay child support. You need their name, their ID, their home and work address. If it's an arrears application and you have a divorce agreement, you would need to take a copy of that. Also proof of your monthly income and expenses. And then the last thing would be a copy of your bank statement, and please not older than 3 months. Your bank details are also on your bank statement. Just if you don't know where the respondent is, I really advise that you, by all means possible, try and get that information and provide it to the courts. They do have the means and the mandate, but they are so under-resourced. And if you're going to wait for them, you could wait forever. And eventually, they will just say to you, look, we can't do it, or we haven't found them. When you have found them, then come back to the courts. So in order to be better prepared and be in certain amount of control, try and provide all the necessary information. So when you've got all your information and all your documents, then you're ready to approach the maintenance court. In Cape Town, in the biggest cities, there's a family court, but in the smaller areas, you would approach the magistrates court. They all have a maintenance section. So the first thing is mundane. You'd go through security. They'll send you to the waiting room. You will fill in a register. They will give you a J101. If you filled it out, well, it saves you a whole lot of time. You don't have to fill it in there. And then you'll wait for the clerk to call you in. So when you go into the clerk, they will just peruse over your application to make sure that you filled it in correctly, that you have realistic amounts that you are claiming, and that you have slips to quantify or justify the amounts that you are requesting. And these are 5 basics that need to really be covered, and that is your education, shelter, food, clothing, and health care. The others are also considered, but it's according to means. So once a clerk has had a look and she's satisfied, then she'll capture all of the stuff onto the system and she'll open up a file. The clerk makes no decision regarding the merit or the demerit of the application. She's really there just to assist and do the admin. They will either tell you that they will send you notice, or depending how efficient they are, they might give it to you while you're there. So that is normally, decision is made by the maintenance officer, who will just go through it, and then they will issue a directive in writing, and requesting them to bring in the necessary documents. The maintenance staff, there's many regulations in the Maintenance Act, but there's one specific one that says that the courts can get the respondent to appear at any means deemed fit, and that's a whole other thing, but we will try and we'll go through that in future episodes. So one way of having the directive served is either by the maintenance officer, their investigator, the sheriff of the court, or by SAPS. There's pros and cons to having SAP serve it, because normally you're required to go with, And if you don't have a very good relationship with the person that you're serving, or there was a lot of abuse in the relationship, often you are subjected to further abuse, if not while you are serving it, but certainly afterwards, by means of text or phone calls. But the good thing is that you get a return of service and you know that he's received it, and that's returned to court. It has to be in court 14 days before the date that you are both due to appear. So if you're not part of the process, you have no idea if the return of service has been returned to the court, and that's where you run the risk of going to court and it hasn't been served, and then it's just going to be postponed. So, you know, there's lots of things that I believe that the clerks can do while you're there to try and prevent all of this, is that they can phone the respondent and go, we are in the process of issuing a directive, and they can WhatsApp it to them, and they can email, send it via Facebook Messenger. Then they can't deny that they don't know anything about it, even if they're battling to serve it. There's just so many loopholes and cracks in the system, and I believe that not just us, but the staff can be a lot more proactive and use the initiatives to have better outcomes from the courts. So something else that I just want to touch on that a lot of people are not aware of is that you can claim for expenses incurred during your pregnancy and the birth, and those are called laying in and birth expenses. And you can also claim for all your costs from the day that the child is born up until the inquiry. I'll put the various sections in the description below. The other thing is that if there is proof of monthly payments, or you have which would be a verbal agreement, or if you've got a written agreement that is not court mandated, it is still an agreement, even though the courts are reluctant to actually consider it as an agreement. It is in the Maintenance Act, and we need to really start enforcing these things. The other thing is debt is not a priority over maintenance payment, and neither are previous children from a previous relationship. All children have a right to be treated equally. It doesn't mean they all get the same amount, but they all are treated equally. So one doesn't get preference over the other. So from next week, we'll touch on your court date. I hope you found that informative. Thank you for watching my channel.